and pleasant good afternoon. Welcome to LawSikho's thorough newspaper analysis for 18th August 2023. Starting with the today's agenda of day, the editorial section covering from The Hindu, Gaps in Births and Death Registration Amendment Act, followed by the news update, which includes the national news, international news, important days, awards and sports, followed by the legal news update. Now, coming up to the editorial section, Gaps in Births and Death Registration Amendment Act. Now, what is the issue in today's article? Let us understand that first. The Registration of Birth and Death Act 1969 provides for compulsory registration of births and deaths under a uniform law across India. Experience of its working indicates that it is necessary to amend it for several reasons. And things could be changing because a bill to amend this act called the Registration of Births and Deaths Amendment Bill 2023 has been passed by Parliament and has got the assent of the President of India. Now, let's have a look at the statements of objects and reasons of this particular act. The statements of objects and reasons attached to the bill states that one of the major objectives is to create a national and state level database of registered births and deaths, which would help in updating other databases, resulting in efficient and transparent delivery of public services and social benefit. Now, for building a database, the bill makes it compulsory that Registrar General of India maintains a national level database of births and deaths, and that the Chief Registrar of Births and Deaths in every state is required to maintain a state level database of registered births and deaths using the portal approved by the Registrar General of India. Now, the database are to be provided information to update the National Population Register, the Aadhaar database, electoral rolls, ration card, passport, and other databases at the national level as may be notified. Now, the one issue that can be pointed out here is, see, in the case of birth, the amendment provided for collecting the Aadhaar number of the parents, but nothing is mentioned about the Aadhaar number of the deceased. Updating many of the databases would require removing the name of the deceased from the database. If the Aadhaar number of a deceased person is not collected, it would be impossible to achieve this objective. So it's a very practical problem that we would be dealing with. So this means that the laudable objective of ensuring efficient and transparent delivery of public services and social benefit would remain a dream. Here, we are confronted with a question, which is, do we need the central and state databases of births and deaths? Are we in need of that? It is to be noted that the registration hierarchy is the responsibility of the state government, with the Registrar General of India having only the role of coordination and unification of the registration system. But now, the maintenance of the central database is being added to the Registrar General of India's function. The Chief Registrar are the executive authorities for the matter relating to registration of births and deaths in state. They need to maintain a database for efficient delivery of services of providing birth and death certificate, and are doing so in many states even now. So the national database is going to be nothing but a collection of state level database, except for some data items that some state may have in addition to the national standard prescribed by the Registrar General of India. So if the authority maintaining other database require information on birth and death, it is possible to design a system wherein the required data flow to their databases on a daily basis or even a real-time basis from the state level database. The Registrar General of India needs to specify the standard for the data structure and transfer protocol. So, with these pointers highlighted by the author above, the question is, what is the need of national level database? Why we are collecting this on the national level? It is provided that this database at the central level be made available to authorities dealing with the maintenance and preparation of database relating to the population register, electoral rolls, Aadhaar number, ration card, passport, driving license, property registration, and such other database at the national level as may be notified. So this is one of the important factors that why are we maintaining the data on the national level. Now, to address this justification, the author in this particular article has pointed out that if those authorities require information from the database of registered birth and death to update their databases, it requires amendment in the laws or executive order under which they are maintained. The Registration of Birth and Death Act only needs an enabling provision to share information from the database. Even that may not be necessary as birth and death register are considered to be a public document in the normal sphere of life. Now, the author further adds a very important point here that listing of a few databases for consideration by Parliament and leaving future additions to the government is demeaning to Parliament in a way. New additions to the list later may be more dangerous than those listed and approved by the Parliament. Now, let's take an example to understand this particular situation. See, the government can now decide that a list of women whose third or higher order birth is being registered be prepared and given to a family welfare department for follow-up on family planning program. Let's understand what changes have been made with respect to certificate of cause of death. With regard to the facilities available now, the state government could decide that a cause of death certificate should be issued by the medical practitioner who attended the deceased person so that certificate can be sent along with the death report. The areas hospital where such certificate has been made mandatory varies across state, but it is generally restricted to deaths in medical institutions. The amendment makes it compulsory that for all deaths in medical institutions, a cause of death certificate be sent to the registrar of births and deaths, and a copy of the certificate is provided to the closest relative. For deaths that occur outside hospital, the medical practitioner who attended to the deceased during the person's recent illness has to issue the certificate. The author here has highlighted that this above stated amendment is fraught with many problems. Now let's look at this problem. First, what are the problems that come up with this Amendment Act? The medical practitioner may not have always arrived at a definite diagnosis before the person died. That is a very high probability. Second, the forms for cause of death that are being used are in conformity with the World Health Organization recommendation. If the disease was attended by a practitioner of Ayush stands for Ayurveda, Yoga, Naturopathy, Unani, Siddha, Stoa, Rigpa, and Homeopathy systems of medicine. The cause of death recorded may not be usable for cause of death statistics since they may not be classifiable under the International Classification of Diseases. Third, a person who was under the treatment of a certain disease can die of an entirely different cause outside a medical facility when the medical practitioner was not available for consultation. How can the practitioner be expected to issue a certificate of cause of death in such cases? Fourth, while under Section 17 of the Act prohibits the inclusion of the cause of death in any certificate issued under the Act, it now says that the cause of death certificate should be given to the relative of the deceased. These are contradictory as the cause of death in death register is taken from the same cause of death certificate issued by the medical practitioner. Now, there is a mention that it is provided that the birth certificate alone would accepted as a proof of date and place of birth for many purposes, such as school admission, issue of passport, issue of Aadhaar number. This may not require any amendment in this act or any other act. It should be possible to achieve this through amendments in the rules relating to those database or even executive orders. For example, while applying for passport, it was compulsory to have the birth certificate for those born after 26 January 1989 under the relevant rules. The present government removed this requirement in December 2016. Now, one issue comes up for the discussion here is the death caused due to the natural calamities. When natural calamities or accidents occur, several persons are reported missing. Many of them may have died too. It has been seen that the police would have to call off the search for them after some time. However, the families of such person would have to wait for 7 years to request for a certificate that says presumed death. Thus, a provision could have been inserted in the Act to register a presumed death when it is reasonable to assume that the person would have died in the calamity or accident. This would help the family concerned get the death certificates earlier. So this was all about the editorial section, which was about the Birth and Death Registration Amendment Act, which has come up recently. Now, starting with the national news of the day, Infosys announces $1.6 billion deal with telecom firm Liberty Global. Infosys has bagged a $1.64 billion deal from Liberty Global to build and scale the entertainment and connectivity platforms of the digital communications firm. The agreement has an initial tenure of 5 years, which can be extended to 8 years, which would take the deal value to $2.5 billion. This is the third big agreement which Infosys has clinched this year. The deal follows HCL Tech's $2.1 billion contract from Verizon last week. So it's a very phenomenal announcement coming from Infosys. Do tell me in the comment box that who is the founding persons of Infosys. Wipro and IIT Delhi launched Center of Excellence for AI Innovation. So next national news, IT major Wipro has launched a new Center of Excellence on Generative Artificial Intelligence in partnership with IIT Delhi. The partnership underscores Wipro commitment to driving ongoing innovation in emerging technologies and is a part of company's $1 billion commitment to accelerating AI-led innovation as a part of Wipro AI 360 ecosystem. The center has been set up on the premises of the Yardi School of Artificial Intelligence at IIT Delhi, and this Center of Excellence will support applied research in generative AI. The aim of this center is to encourage and better the research and development capabilities in several emerging areas such as generative AI and then connect the candidates with a talent pool. The next national news of the day, ex-Gujarat Chief Minister Suresh Mehta launches non-political platform to spread awareness among voters. Former Gujarat Chief Minister Suresh Mehta announced the launch of a non-political platform as an attempt to present an alternative narrative and spread awareness among voters about different issues. Now, as a part of this initiative, which is named as Jan Abhiyan Badle Gujarat, a research and training institute will also be open to train elected representatives on various aspects related to their roles, responsibilities, and power, said the 87-year-old Mr. Suresh Mehta. Now, Suresh Mehta was the Chief Minister of Gujarat between 1995 to 1996. As per Article 150 of the Constitution, now we are linking here what is the legislative aspect of this particular news. The account shall be kept in the prescribed format approved by the Comptroller and Auditor General of India. Now, Cabinet approves extending Digital India program. In a significant development, the Union Cabinet on August 16th approved a 5-year extension and expansion of Digital India program, including an expansion of Computer Emergency Response Team India. The expansion of the program, established in 2015, will have an outlay of 14,900 crore rupees. Minister of Electronic and Information Technology Ashwini Vaishnaw said. Under the ambit of Extended Digital India project, several crucial objectives have been outlined, each aimed at bolstering India's technological capabilities. For example, the program is with a view to establish IT professional upskilling, IT training, digital empowerment for enterprises, information security training, AI Center of Excellence, enhancement of cyber forensics, and startup support in Tier 2 and Tier 3 cities. Now, India's first drone testing center to be set up in Tamil Nadu. A very important news in perspective of the examination. The country's first common testing center for manned aerial system drones would be established in Tamil Nadu at an outlay of rupees 45 crore. Tamil Nadu Industrial Development Corporation is the nodal agency for the implementation of the TN Defense Industrial Corridor, and one of the strategies of the corridor is to provide an ecosystem for the aerospace and defense industry. For setting up such common testing center, the Tamil Nadu Industrial Development Corporation has floated a request for proposal for identifying industrial partners. Now, coming up to the next national news of the day, IAF, that is Indian Air Force, places order worth 300 crore with Veda Aeronautics. The Indian Air Force Center has taken a huge step towards supporting the domestic drone startup ecosystem in India by granting a contract worth rupees 300 crore to Veda Aeronautics drone, an Indian defense startup, for 200 swarm drones. This is the part of Indian Air Force Meher Baba 12 drone competition, the aim of which to stimulate domestic innovation and technological growth in the field of unmanned aerial vehicles. Now, coming up to the next national news of the day, Chhattisgarh High Court starts live streaming proceedings on YouTube. The Chhattisgarh High Court has started live streaming its court proceedings on YouTube. On this occasion, the Chief Justice also inaugurated e-service center in 22 districts, a mobile app in relation to e-gate pass, an online recruitment application and software with respect to virtual court regarding traffic challan for the district. Additionally, a new Telegram channel for causeless tender process, judgments and important notices were also launched. The causeless judgments, important information tenders have also been available on the High Court website. It is to be noted that Gujarat High Court was the first High Court in the country to live stream its proceeding in 2020. It was followed by several High Court across the nation, that is Guwahati, Karnataka, Madhya Pradesh, Odisha, Patna, which is not currently functional, Telangana High Court and Meghalaya High Court. The initiatives to live stream court hearings were taken pursuant to the decision of the Supreme Court. The very important decision, Swapnil Tripathi versus Supreme Court of India in the year 2018. These collective decisions were rooted in the pursuit of transparency and the desire to grant wider accessibility to the court hearings. Now, coming up to the next national news, G20 Film Festivals begins in New Delhi. The G20 Film Festival began in New Delhi on August 16. India's G20 Sherpa Amit Kant inaugurated the festival. Satyajit Ray's Patthar Panchali was the opening film. It was inaugurated by veteran actor Victor Banerjee and India's G20 Sherpa Amitabh Kant. The event will continue till 2nd September. What is the aim of this festival? The festival aims to celebrate and showcase a vibrant and collaborative partnership existing among the G20 and invited countries in the field of cinema. And it is organized by the Indian International Center and the G20 Secretariat of the Ministry of External Affairs. Now, coming up to the international news today, PayPal names Alex Chris as its new CEO. PayPal Holdings has announced a major leadership change, appointing Alex Chris as its new president and CEO from 27 September 2023. Now, coming up to the next international news of the day, Neymar quits PSG to sign for Saudi Arabia's Al-Hilal. Brazil star Neymar has signed for Saudi Arabian side Al-Hilal, a professional multi-sports club based in Riyadh and Saudi Arabia. From French champions Paris Saint-Germain, a professional football club based in Paris and France. The agreement for the former Barcelona player is reportedly valued around 90 million euros, including potential add-ons and other benefits. Neymar, a 31-year-old, scored 118 goals in 173 matches for uh, Paris Saint-Germain in 6 injury-plagued season. He won 5 League One titles and 3 French Cups, but was on the losing side as Paris Saint-Germain were beaten up by Bayern Munich in 2020 Champions League. Coming up to the legal update of the day, partition can also be affected under a settlement or oral understanding by the Honorable Supreme Court. The Honorable Supreme Court observed that a partition can also be affected under the settlement or oral understanding. There is no provision to affect a partition otherwise than through an instrument in writing by duly complying with the requirements of law. We are alive to the principle that there is no prohibition to affect a partition otherwise than through an instrument in writing by duly complying with the requirement of law. In other words, the division may also be affected under a settlement or oral understanding which is held in the case of H. Vasanthi versus A. Santha. Now, coming up to the next legal update of the day, maternity benefit must be granted even if period of benefit overshoots term of contractual employment by the Honorable Supreme Court in the case of Kavita Yadav versus Secretary Ministry of Health and Family Affairs. The Honorable Supreme Court on Thursday held that maternity benefit have to be granted even if the period of benefit overshoots the term of contractual employment. Maternity benefit can travel beyond the term of contractual employment. The court directed the employer to pay maternity benefit as would have been available in terms of Section 5 and 8 of Maternity Benefit Act 1961 and payment to be made within 3 months. The court underlined here that the statute itself envisions the continuation of benefit beyond the term of employment, asserting that entitlement to medical benefits as stipulated under 5 of the Maternity Benefit Act goes beyond the confines of employment duration. That's all for the today's news update. Thank you so much.